Hi, Dan Krause here, and today I want to talk a little bit about giving money to minors, to minor children, which, you know, 25 cents or a couple of dollars here and there don't make a difference. But if you want to give a minor child, say, $100,000, that may be a problem. And it's more of a problem if you do it through a will or if you don't have a plan at all. So, I want to talk a little bit about that today. But first, I want to invite you to subscribe to our email newsletter. If you'll just email us at newsletter@friendly.law, that's newsletter@friendly.law, we will be happy to sign you up for a wonderful newsletter that you can get every month. So, many people have young children or grandchildren or nieces, nephews, favorite people who are below the legal age. And many of us would like to give those youngsters money if something happens to us, if we die or become incapacitated and then later pass on, or even during life. We may want to give those children some money, something to give them a boost later on in life. What's a great way to do that? Well, the best way to do that is through a trust so that an older person can manage those assets for that young person until the young person becomes of age. Not necessarily a person that manages it, but it's a trustee. It could be an institution, it could be a bank, a trust department that knows how to manage money, because a 5-year-old or 6-year-old or 7-year-old would probably mess it up. Now, I know that I'm sure some of my viewers are going to say, well, their kids are geniuses and they could break the stock market if they were allowed to invest. Well, that may be true for a very, very small percentage of young people, but we're talking about the majority of young people. What brings this up? Well, I have had a few cases recently where the courts have called me up and said, hey, we've got this case that's in the probate court, and a young person, a 5-year-old, a 12-year-old, a 15-year-old, are going to be inheriting money. And the court needs, more than the child needs perhaps, the court needs to appoint a GAL for their benefit. So, what's a GAL? A GAL is a guardian ad litem. Oh, that doesn't tell you a whole lot. A GAL, guardian ad litem, is an attorney appointed to represent the best interest of a person who can't appear or is incompetent or is not old enough to make decisions for themselves. That's what a GAL is. Now, a GAL is sometimes mistaken for the minor's attorney. It's not the minor's attorney or the incompetent person's attorney. It is an attorney appointed to represent their best interest. So there is a difference between a person, what they want, which is what your attorney is supposed to advocate for, and what is in their best interest. So what a child wants is nothing but candy. What is in their best interest is fruits, vegetables, and that kind of stuff. So the GAL would be arguing that kid needs to eat more fruits and vegetables, and the child's attorney, on the child's insistence, would be arguing that kid needs more chocolate and more other types of sugar. Okay, so that's the difference between a GAL and an attorney. And why am I telling you all this? I'm telling you all this because it's expensive to give money to a minor if you're going to do it through the probate court. Oftentimes, the GAL needs to be appointed for the best interest of the child because that's the law. That's what the court says has to be done. Why is this bad? Well, it seems great, and it's a great idea. However, it costs money. So the child's inheritance is going to be lessened by the cost of the GAL and these court proceedings. How can you avoid this? Well, if you plan with the trust, if you put all of your assets into a revocable living trust before your death, and then you give your money to the minor children, there doesn't have to be any GAL because there's no court that needs a GAL's report before they can make a decision about how to give the money to this child or who to appoint as the trustee for this child, etc. So that's just a little lesson about giving money to young people. It's a little more complicated than people realize. And if you do have young people that you want to get money, please consider creating yourself a revocable living trust based package to plan your estate. And then you may be able to avoid many, many costs of court, including the GAL that would be appointed for young beneficiaries. I hope you learned a little something. Thank you for watching. And just all these hand gestures, I hope they're okay and not distracting. My mom said, I've been watching your videos and I think you should use more hand gestures. So thanks, Mom. Hope you watch this. I hope you enjoy the hand gestures and come watch more videos if you enjoyed this. Thank you.